Welcome to This Explainer. Today, we're doing something really exciting. We are decoding the complexities of Kenyan probate law together. Now, I know probate law might sound a bit dry at first, but honestly, it's a brilliant, highly logical system. It's totally designed to protect people and property during life's most vulnerable moments. So we're going to break down the exact legal mechanisms used to prevent absolute chaos when someone passes away. Okay, let's dive into this structured roadmap. We'll start by looking at the estate administration gap. Then we'll cover grants limited by purpose, handling urgent estate emergencies, grants limited to time, grants limited to property, and we'll wrap it all up with the golden rule. First up on the agenda, Section 1, the estate administration gap. To really grasp why these specific laws exist, we have to ask a very real-world question. Picture this. What happens to pending lawsuits, expiring leases, or urgent medical emergencies when someone dies? Because let's face it, life, business, and legal disputes, they don't just politely hit the pause button because someone passed away. There's this precarious gap between the exact moment of death and the moment an estate is finally distributed to the heirs. And listen, this gap is incredibly strict. Under Section 45 of the Law of Succession Act, anyone is expressly prohibited from dealing with a deceased person's estate in any way unless they are expressly authorized by law. The law literally freezes the assets. If you try to step in and handle things without authorization, you're actually violating this section. This is exactly why we need legal stopgaps to step in and prevent total chaos. Which brings us to Section 2, our first main category of solutions. Grants limited by purpose. The very first purpose-driven solution is the grant ad litem. You'll find this in Schedule 5, Paragraph 15 of the Act. It's specifically issued to either take over a pending lawsuit against the deceased or to start a brand new action on behalf of the estate. Let's think about that for a second. Imagine a landlord who passes away, and they leave behind several defaulting tenants. You can't just go collect that rent or sue those tenants without authorization. Or consider a tragic accident where a victim dies, and the family desperately needs to sue for damages under the tort of negligence. They can't just sue in the deceased's name. They need a grant ad litem to legally step into those shoes and commence that legal action. Now, to navigate the bureaucracy and actually petition the court for this grant, you need to submit the petition using statutory form PA-90B, and that has to be accompanied by an affidavit using form PA-19. It's a very structured process, perfectly designed so the court gets all the exact facts it needs right out of the gate. Alongside those forms, you're going to need what we'll call the usual suspects. The deputy registrar expects to see the death certificate, a letter from the local chief, and critically, consent from the other beneficiaries who are over the age of 18. On top of that, you absolutely must provide the exact particulars of the defendant you intend to sue, or attach the summons of a pending litigation if you're taking over an existing case. Now, what's really interesting about this slide is how the law handles family disputes. A grant pending daylight is used when there's a pending legal battle, specifically a bitter dispute over the validity of a will or over who actually has the right to administer the estate. If heirs are fighting over whether a will is valid, the main administration of the estate is totally stalled. This grant allows someone neutral to step in temporarily, literally just for the duration of that specific dispute. It basically ensures the estate isn't completely paralyzed while the heirs battle it out in court. Moving right along to Section 3, handling urgent estate emergencies. For highly sensitive, absolutely critical situations, the law allows for a special, limited grant. This provides urgent intervention to prevent an estate from wasting away or to cover an extreme, unique medical emergency. Like, what if a surviving spouse falls incredibly ill with a condition requiring immediate, super expensive medical attention, but all the funds are tied up in the deceased's frozen accounts? Well, in these cases, the petitioner must make a physical appearance before the judge. This physical hearing is crucial because the judge has to cross-examine the facts, prove the strict boundaries of the urgency, and make completely sure this grant won't be abused. There's another fascinating emergency tool here, the Section 49.3 Magistrate Exception. Normally, limited grants do not let you dispose of assets, but this is a rare exception. If you can prove apparent urgency, a local magistrate can issue a temporary grant allowing an administrator to collect local assets and explicitly pay off urgent debts. Think about it. If the deceased had rental properties with a pending encumbrance or mortgage and failing to pay it right away would lead to foreclosure, this grant allows an administrator to collect the rent and immediately pay off that specific urgent debt to save the property. It's a real lifesaver. Next up, Section 4, grants limited to time. This category is all about the clock. First up here is the CSATE grant, located in Schedule 5, Paragraph 21. This comes into play when an administrator was given a grant that was strictly limited to a specific time frame, say 6 months, but that time is expired, and the administration remains incomplete. Why would this happen? Well, practical, everyday, real-world issues. Often government online portals experience massive delays, or simply finding certain documents takes way longer than expected. When the clock runs out but the job isn't done, the administrator applies for a CSATE grant to get additional time to finish up. And this brilliantly illustrates a common point of confusion among legal practitioners that we need to clear up right now. A CSATE grant is used when the original time simply ran out, but the original administrator is still alive and actively doing the work. On the flip side, a grant de bonis non administratis, which translates roughly to goods not administered, is used when the original administrator actually dies mid-process. As established in the famous case of the estate of Hunter and Juki, if an administrator dies, their heir cannot just cross out the name and take over. No way. They must formally apply for a new grant de bonis non administratis to fill the gap left by the deceased administrator. Let's shift gears to Section 5, Grants Limited to Property. Schedule 5, Paragraph 13 tackles a very specific scenario. It's issued when a deceased person held property purely as a trustee, meaning they didn't actually own the beneficial interest of the property themselves. Let's bring this to life, okay? Imagine a man named Zed who is holding 2 acres of land in Nanyuki in trust for a minor named Y until Y turns 18. If Zed dies, that land does not belong to Zed's estate. To protect that specific asset, another surviving trustee or a newly appointed one can apply for a grant limited solely to those 2 acres in Nanyuki, just to secure it until the minor comes of age. Another highly specific property grant falls under Rule 28, which deals with foreign domicile. Domicile is essentially the place a person considers their true, permanent, fixed home. If someone dies and their permanent domicile was outside of Kenya, let's say in the UK, but they owned an immovable property, like a house, inside Kenya, Rule 28 gives Kenyan courts the specific jurisdiction to issue a grant limited just to that local immovable property. This ensures it's managed according to Kenyan law, regardless of where they lived. Which brings us to our grand finale, Section 6, the Golden Rule. So the crucial point is this: these are merely stopgap measures. Let me repeat that. None of these limited grants allow anyone to distribute the estate. Whether you're suing a tenant, securing trust property in Nanyuki, or pausing proceedings to fight over a will, you are only collecting and preserving assets. You're protecting the estate from wasting away. Aside from very rare exceptions like paying an urgent debt under a magistrate's direction, a limited grant never ever gives you the power to permanently distribute the wealth to the heirs. That requires a fully confirmed substantive grant of representation. Which brings us to our final thought. If the law has to go to such incredible lengths, creating all these temporary, highly specific stopgaps, just to handle the emergencies that inevitably pop up when someone dies, how protected is your own legacy right now without a clear, undisputed will? It's a provocative thought to leave you with, right? Thank you so much for joining me in this explainer today. I truly hope this structured journey through Kenyan probate law empowers you to better understand and, frankly, take control of your own legal affairs. Keep learning, and I'll see you next time.